we know there were dozens of officers on scene. Dozens of officers who were eyewitnesses to the conduct that occurred. The state didn't call a single one of them. Why? Nothing they would say is consistent with their story. In fact, all the experts relied upon their statements, and you didn't hear any information from any of these officers that suggested for 1 second that Officer Collins, Officer Burbank did anything inappropriate. Even more, once Mr. Ellis is restrained in 4-point restraints, not a single officer thought it was excessive force, or that Officer Rankin or Ford or Sanders or Lim, anybody else, Madden, who touched and restrained Mr. Ellis, did so inappropriately. Those are the facts. The state suggests that there was some duty of care that my client violated that somehow makes him criminally liable. Well, I'm going to ask you, look at your instruction packet. Do you see any instruction from the court that says any duty of care makes this criminal? No, because it doesn't. You have to commit an unlawful act and cause the death. The duty of care is just a way to try to get you guys to go around what the instructions are. Every officer on scene, according to that theory, had a duty of care. Every single one. Does it make it criminal? Maybe civil liability. This isn't a civil trial. Not a single instruction says that creates criminal liability, because it doesn't. Excusable. And actually, the 2,400 nanograms in the enlarged heart gets back, I just discussed it, but go look at instruction 25. If those are things that the defendant, Mr. Ellis did that caused death, those are intervening causes. So even if you think Officer Collins' conduct somehow caused the death despite the evidence not showing that, that's what we call a superseding cause. All right, excusable. Excusable. You have instruction number 33 that talks about excusable. Not only does the state have to prove the elements of the two convict instructions beyond a reasonable doubt, look at instruction 33. They also have the burden to disprove the acts are excusable beyond a reasonable doubt. Meaning they have to disprove this. Well, what does instruction 33 say? Homicide, which is either murder or manslaughter, is excusable when committed by accident or misfortune in doing any lawful act by lawful means. Let's stop there for a second. So if they have the probable cause to arrest Mr. Ellis, they restrain Mr. Ellis, and he dies as a misfortune of these other circumstances during the course of that, it's not a crime. And the state has to disprove that beyond a reasonable doubt. Have to disprove it beyond a reasonable doubt. It goes on to say without criminal negligence or, right? So I think the state was going to suggest to you that some of their acts were negligent, therefore they've disproved this. But that's disjunctive, folks. Or means they got to disprove this too, that it was without any unlawful intent. They had to prove that there was unlawful intent. Disprove, right? Officer Collins and Burbank intended to harm him criminally to disprove this. And there's no evidence of that. And the state has the burden of proving the absence of this beyond a reasonable doubt. Didn't do it. How about lawful? Not only does the state have to prove the elements, they also have to prove the conduct was not lawful as it relates to the unlawful imprisonment and or the assaultive conduct. Well, you have instructions about what lawful is, and that the state has to disprove beyond a reasonable doubt in that regard too. So it's lawful when necessarily used by a peace officer in the performance of their legal duties, right? So if I'm a cop and I'm doing what I'm supposed to do and I lawfully arrest somebody because I have probable cause and it was necessary to restrain him, it's not a crime. And the state has to disprove that beyond a reasonable doubt. In fact, instruction 29, if after notice of intention to arrest a subject, I'm going to submit to you in They're trying to restrain Mr. Ellis. He's given notice of intent to arrest him. A peace officer may use all necessary means to effect the arrest. Take that in conjunction with the instructions I told you about yesterday about if you have probable cause to arrest, and if they're resisting, you get to use all necessary means to restrain him. That's what happened here. It's lawful. And the state has to disprove that beyond a reasonable doubt. And they didn't. Again, we're done. Ms. Eakes urged you to use your common sense. I'm going to urge you to use your common sense as well. Because your common sense tells you it did not happen how Ms. McDowell, Cowden, and Lowry suggested, or how the state has suggested in this case. Nothing about that fact pattern or theory makes any sense. That would make zero sense for them to jump out of their vehicle and attack someone walking down the street. Because that's not what happened. Common sense, why in the world would they do that? You not present any evidence as to why they would do that. These two officers just decided they're going to attack somebody on March 3rd for no reason. If that were true, why did they not inflict other injury to Mr. Ellis? Mr. Ellis had superficial injuries, right? He had some road rash on his face because they're trying to restrain him and his head's against the concrete. He's got road rash on his knees and hands because he's resisting on the cement. And he's got a couple hematomas swelling around his eyes where Officer Collins delivered some strikes. No broken bones. No injury consistent with them attacking somebody in the manner the state suggests. In fact, if that were true, what you probably would have seen is on Exhibit 21, where my client is saying, put your hands behind your back, put your hands behind your back, you would have seen my client punching him because he had him, striking him because he had him in a position where he could have done that if that's what his intent was. And there's just no evidence of that. So I invite you to use your common sense. The state doesn't have to prove motive. It's not an element. But you have to ask yourself, why in the world would Matthew Collins risk everything, just had a baby, why would he randomly attack some guy walking down the street? Why would he risk everything? Why would he do everything counter to who you know he is, as the state suggested? Because that's what you have to find. That's what you have to believe, unsupported by a single piece of evidence. How about this? How he just happened to pick the one victim who had 2,400 nanograms of methamphetamine, a dilated heart, and fights police. What are the odds of that? I'm sorry. And fights police. It's clear. It should be clear, based on all of these reasons to doubt and what you sat through for 3 months. The state did not disprove this was lawful, beyond a reasonable doubt. The state did not disprove that this was excusable, beyond a reasonable doubt. The state did not prove that my client committed a felony that wasn't justified. The state did not prove that anything my client did cause the death. And those are what they have to prove and disprove beyond a reasonable doubt. Mr. Arbins, I think in his opening, maybe during jury selection, quoted Thomas Jefferson about this process. Right? He said, trial by jury is the greatest anchor ever imagined by which the government can be held to the principles of the Constitution. That's what this is about. Hold them to those principles, because they didn't come close to proving it. Find Matthew Collins not guilty because the state didn't prove or disprove, but also find him guilty because he is not guilty because he is not guilty. He committed no crime. He did his job, and it's tragic that Mr. Ellis died, but it's not criminal. Thank you.